I'm Stephen Friel. I'm a lawyer and litigator by background and now Chief Executive of Woodsford Litigation Funding. Woodsford is one of the more well-established funders in the international litigation community. We're headquartered in London and with an office in Philadelphia, and we fund high-value litigation and arbitration across the world. So Woodsford was formed in 2010. So at 7 years in, that makes us one of the more well-established of the London group of funders and now a well-established player across the globe. So we're headquartered in London and we've recently opened an office in Philadelphia, which is our first US base. We have an eye to the Asian market and are likely open in Singapore next year. We have 10 full-time executives spread across London and Philadelphia, and we draw on another collection of non-executives, including our investment advisory panel. So there are about 24-25 people associated with the business. We were founded in 2010 by Yves Bonavero. Yves is a serial entrepreneur. He was formerly CEO of EDF in Man and helped grow it into the Man Group that it is today. And since moving on from the city, he's founded and grown a number of businesses. So in around 2009-2010, he's seen the growth of this relatively new finance litigation funding industry and thought that it was a good model and something that he was keen to try. We had lawyers in the business at the time, so together they formed Woodsford Litigation Funding. We probably intended at the outset to be a fairly Anglo-centric business, funding mainly English and English common law litigation. But the way in which the business and the industry generally has developed is much more international. And as a result, whilst we're very established here in the UK market, we are funding across the globe. We specialise in providing access to justice, so we look for good cases, we like high value cases, and within that we have no real no-go areas. We prefer commercial disputes, which are based on contract, patent, antitrust, competition law, securities, and other forms of relatively straightforward commercial disputes. We don't have a specialism in personal injury or any other type of dispute, but we are fairly flexible and we'll look at any good investment opportunity with meritorious claims where we feel that we are providing good investment and access to justice. So if there's an attorney out there that isn't really sure about what the litigation funding options are, they should give us a call. We have a team of litigators here who have all been on the other side. We've all been with major international law firms and boutique litigation practices, so we know what it's like to be on the other side. So the best advice is just give us a call, tell us what your request is, and we can talk it through. Then in terms of how best to present an opportunity to us, well, litigators are advocates. They're supposed to be able to tell a story. So tell us what the story is. Who's the claimant? Why do they want our funding? Who's the defendant and why are you suing them? Are they good for the money? Which court or tribunal will hear the dispute and can we trust them to get it right? What are the likely damages? What's the amount of dollar value in dispute? And what commitment do you require from us? What is the budget and the timeline to take this through to completion? So I don't view the litigation funding market as a UK market or a US market or a European market. I see it very much as an international market. Most of the law firms that we're dealing with have an international outlook. They usually have offices in more than one jurisdiction. And we see this as an international business. The UK market, to the extent that there is one, is very competitive with litigation funding. Woodsford sits alongside another group of well-established players in the market. So we're always looking for new territories in which to expand our business. The US is a major growth area for us. Some people think that's almost a paradox that the most litigious and the most entrepreneurial environment in the world still offers growth opportunities and litigation funding. But actually it's a big country, and there are parts of that country that are relatively untouched by litigation finance. And there are many very good law firms that don't yet understand the benefits of litigation finance. So we're going to focus on the US over the next 2 to 3 years. We're interested in Latin America, and we have a joint venture with one of the first movers in the Latin American market. Asia is interesting. Hong Kong and Singapore has recently liberalized their respective laws on litigation finance, and that provides an excellent opportunity for us. So I would expect us to be physically present in Singapore as of next year. And of course, there's always Australia. Australia was one of the first jurisdictions to identify the opportunity in litigation finance, and there's a very well-established market there. Arguable how much growth there is in that jurisdiction, but simply by virtue of its hospitable nature, we're likely to spend some time there too. Yes, so right now funding, third-party funding for disputes is permitted in each of Hong Kong and Singapore only in respect of arbitration. Litigation funding, i.e. the funding of domestic litigation matters, is relatively limited in each of those jurisdictions, and really devoted only to insolvency cases. However, when the respective working groups in each of Hong Kong and Singapore were looking at the law and practice of litigation funding over the last couple of years, they made it quite clear that they understand that in order for any jurisdiction to maintain a position as a leading centre for dispute resolution, that jurisdiction needs to be supportive and embracing of litigation finance. So I believe that the liberalisation in Hong Kong and Singapore, which currently extends only to arbitration, is but a baby step towards full liberalisation in those jurisdictions. Yes, that's a good question. One of the interesting features of running a litigation finance business is that in many jurisdictions our product is fairly novel, and not a year goes by when another crop of jurisdictions comes out and either changes its laws or changes its commercial practice to embrace litigation finance. So in recent times we've seen Hong Kong and Singapore change its laws, and we've also seen a revolution in the way that lawyers in continental Europe and Latin America, where litigation finance has always been permitted, never been prohibited by ancient champerty and maintenance principles, the lawyers in those jurisdictions are changing their practices to embrace litigation finance. Where are the next jurisdictions to change? I've seen a growth in interest from Japan and South Korea, and also China. There are also parts of Africa, including South Africa, that are waking up to litigation finance. But really this is a global business, and only a relatively small part of the world is currently using litigation finance to its full capacity. So there's amazing growth potential. Continental Europe has traditionally been accepting of litigation finance. There have never been legal prohibitions to the same extent that we've had in the English common law world. But there's never been much of a practice of using litigation finance for various reasons. But places like Germany and the Netherlands in particular, also Spain and France, are waking up to litigation finance. And we're seeing more and more law firms in those jurisdictions contact us, and we're funding our first cases on the continent. We have ongoing investments in France and the Netherlands, and I would expect that we will make our first investments in Germany by the end of this year. So traditionally the main users of litigation finance, being non-recourse third-party litigation funding, have been the big and usually international law firms. But that means that there is great potential outside that small cohort of major international firms. We have identified that in the US in particular, there are hundreds if not thousands of very good boutique law firms, ranging from the 2-3 partner law firms up to the 20-30 partner law firms, all doing excellent work and winning good cases, and currently not availing of litigation finance. We're looking for those firms. We want to work with them. We want to support them in their contingency fee work, and we want to work with them and partner with them on supporting meritorious claims. The market in litigation finance for the top AM law firms and the white shoe firms and the English Magic Soga firms, that's a fairly competitive space. We're in that space and we're competing well, and we're working with many of those firms. But I would expect that our main growth over the next few years will come from boutique and smaller firms. The firms that we're happy to work with, that we want to work with, are firms that are doing good business, litigating and winning cases. And the big firms do not have a monopoly on good litigation practices. We've seen a growth in the UK and in the US of litigation boutiques growing out of bigger firms, usually driven by the need to be in a conflict-free environment. There are partners out there that got fed up turning down cases against the big banks or the big corporates because their firms weren't in a position to act against those defendants. And many of those are now in good entrepreneurial boutique practices. We're already working with some of those, and we're looking for more to work with. So litigation finance is developing, and the law and practice of how litigation funding and finance is used is developing every day. To give one good example of how the law is developing, Woodsford funded an ICC arbitration in the oil and gas space. We funded the claimant in an ICC arbitration before a sole arbitrator seated in London. That claimant was successful. The defendant was ordered to pay substantial damages to the claimant, and is often the way in ICC arbitration. The defendant was ordered to pay the claimant's costs. Interestingly, however, the arbitrator went further and ordered the defendant to pay the claimant's litigation funding costs, i.e. the additional costs of accessing relatively expensive third-party funding costs. That ICC decision was appealed to the High Court here in London, which had supervisory jurisdiction over the arbitration, and the award was upheld. So that opens up the prospect that losing parties will be ordered to pay the winning party's third-party litigation funding costs. Very interesting decision, absolutely correct in my view. If a defendant or any party causes another party loss, I think they should be held liable for that, and the rules of the ICC arbitration provided that they should be held liable. But what that tells us is that litigation funding could therefore be used by defendants in the same circumstances. A defendant who is faced with an unmeritorious claim and feels the need or is required by its financial resources to seek third-party financing, could, if successful, and if the arbitrator is so minded, seek to recover third-party litigation funding costs from the claimant. So the SR and Norscott case in itself and the applications of it show that good litigation lawyers in partnership with good litigation funders can come up with imaginative ways to use litigation finance as a way of shaping behaviour on the other side of the litigation. One normal way of structuring a litigation funding agreement is that in return for the commitment from the litigation funder, upon success, the litigation funder expects a return. That is often calculated either by reference to a percentage of the winnings or as a multiple of the commitment put up by the funder in the first place, or some combination thereof. So in defendant funding, the percentage of the winnings could be calculated by reference to the amount saved by the defendant in fending off an unmeritorious claim. Alternatively, it could simply be a multiple of the funding commitment made by the funding business. So if we were, for example, here at Woodsford, prepared to fund a defendant $1 million in defence costs, in the event of success, we could seek a 2 or 3 times multiple of our commitment from the defendant. And if the defendant has just fended off a 200 or 300 million claim or even a 10 million claim from a claimant, its financial position may be such that it is then in a position to pay our funding costs. And in that respect, you can see that litigation finance is a hedging tool. It's a way for a party, whether a claimant or a defendant, to take third-party investment to hedge against the risk and uncertainty in litigation. And in the event that that litigation is successful for whichever party, it will then be in a position to share its financial upside with the funder. So when we're approached with a litigation funding opportunity, our objective is to decide whether to do it as quickly as possible. Two reasons for that. First, if it's a good opportunity, we want to get on it quicker than our competitors. And secondly, if it's not a good opportunity, we don't want to waste ours or anyone else's time, and we want to move on quickly. The greatest challenge in litigation funding and doing the due diligence and underwriting of the cases that are brought to us is getting the right information as quickly as possible. What we want is fairly straightforward. We want to know who is the claimant, who is the defendant, who are the parties, what is the case all about, what's the forum that will be deciding the case, what's the budget, and what's the timeline. Getting that information is not often straightforward. And one of the reasons for that is that we fund across the world. We're dealing with lawyers in many jurisdictions, some of whom have no experience of dealing with third-party funders. So the process of getting the information can be fairly lengthy. But once we've got it, we have a team of in-house litigators who have experience of litigating around the world. They quickly delve into the papers, they speak to the lawyers, they speak to the key witnesses, and over a relatively short period of time, so we're talking a small number of weeks, really get to grips with the case. If we're going to say no, we want to say no quickly, and most of the cases that we decline, we do so within 2 or 3 days of the first inquiry. The cases that we're going to say yes to usually take about 6 weeks to get over the line. Once the executive team have decided that this is a case that we want to invest in, the next stage in our due diligence process is to send the opportunity to an investment advisory panel. Our investment advisory panel is a non-executive body made up of very senior lawyers and judges and arbitrators who are provided with the information by us, by the executive team. We give them a summary of the case and a bundle of the papers, and we ask them for their views. It's an advisory body. It doesn't have decision-making power. It simply tells the team what they think. And then finally, if the executive team thinks it's a good case and the investor advisory panel think it's a good case, then our board considers it and we make the investment. So the whole process takes 6 to 8 weeks. So I think the best decision the company has made is to get into the litigation finance business in the first place. It's a new, rapidly growing business. It's interesting. It's working with good lawyers and providing access to justice. And most importantly, from a business perspective, it's profitable. There are good returns to be made from making good decisions on good cases. I don't think there is a single worst decision that we've made. Clearly, as or when we lose cases, we think, well, we shouldn't have invested in that case. Fortunately, we don't lose many cases. Our underwriting is rigorous, and we win the majority, indeed the vast majority of the cases that we invest in. We wouldn't be around as a business for very long if we didn't invest in good cases. But even the cases that lose, we can look back on and we can learn from them. There are lessons to be learned about the type of law firm to partner with and the type of contractual arrangements to have with them, the types of cases that provide the certainty that we require, the type of information that we should seek at the outset of a case, and the amount of involvement we should have on an ongoing basis. We live and learn. In terms of wow moments, one of the difficulties about our wow moments are that often our involvement in cases is confidential, and our best wow moments are making a good return, but we can't often speak about those. One of the cases where we've had a great success and is in the public domain is the SR and Norscott case, which is the ICC arbitration where we funded the claimant to great success. So much so that the arbitrator ordered, and the English High Court agreed, that the defendant should pay our litigation funding costs. That was a great success for us and a great development in the law and practice of litigation finance. One of the biggest changes from moving from being a private practice litigator at an international law firm to being the chief executive of a litigation finance business is the degree of control over the cases. As a litigator, I enjoyed being the project manager of the dispute and being very much ingrained in the day-to-day mechanics of the case and feeling ownership over the case. I still feel ownership over my cases as a litigation funder, but I have less control. I'm one stage removed, and as a litigator, I miss that a little bit. I like the control. The upside is that I can then spend my time looking at a much greater variety and diet of cases. As a private practice litigator, I would handle maybe 10 active cases at any given time. Here at Woodsford, we're looking at dozens of cases at any given time, and we're invested in many. So the relationship between the funder and the lawyers handling the case is critical, and it's one that we need to get right. And I think we do a very good job of it here at Woodsford. If we meet a law firm and we're looking at an opportunity and we feel that it's a good opportunity, but the law firm would need a lot of management and a lot of hand-holding, we're probably not going to make that investment. We want to partner only with law firms that we trust and that we can allow them to get on with the case with input from us as or when they need it, and we can certainly provide input. We have great litigation and financial acumen here in our business, and we're happy to deploy that into our investments. But we don't want to be micromanaging. That would not be a good result for the law firm or the plaintiff. We want them to get on with extracting the value from their case with our support, but not with micromanagement. We work with a number of law firms across the world. To give you some examples of relationships that we have, we're working with one law firm on a series of investor-state arbitrations. They're doing a fantastic job, and we're very happy with how the cases are progressing. We check in with them once every couple of months. They give us an update. We have a nice lunch, and that relationship goes well. They don't need a lot of input from us, and we're happy to allow them to get on with it. With another firm, we have a much more active relationship. We have a particularly good rapport with the firm. We speak to them on a weekly basis. We exchange emails frequently, sometimes daily. They enjoy our input, and it's a case on which we've got a lot to say, and they and their clients, our plaintiff, enjoy our input. That's a much more active relationship, and much like the first case I mentioned, it also works. It's horses for courses. In terms of growth, the growth of the industry generally is potentially exponential. It's very difficult to estimate the size of the market, but if you start at the size of the litigation market or even the size of the legal services market in contentious matters, and then look at where litigation funding has been successful and what percentage of litigators in fairly good advanced jurisdictions like the UK use litigation finance, well, what doing simple arithmetic like that tells us is that there's a tenfold increase over the next few years, potentially. As to our business, we're a relatively conservative and prudent business, and we want to grow conservatively. But I would expect that the level of commitments that we'll make over the next 3 to 5 years will be in the level of about 3 times what we've made, the commitments that we've made in the first 7 or 8 years of our business. So quite an increase on commitment. We fund a wide variety of cases, from US patent cases at one end of the world to environmental mass tort claims in Europe, through to Australian securities class actions. There's a huge variety of cases in which we're invested. And as a result, it's difficult for us to say what a usual time period or a usual budget would be. But as a diversified portfolio manager, we want to get a good spread. And for every case that we'll get a return within 6 months, and we've had a couple of those, there will be other cases that will take 5 to 7 years. And my objective is to make sure that we get a good balance of those different types of cases in the portfolio so that we're averaging a 2 to 3 year return on our investments. Yes, we are. We're always on the lookout for new talent. We've recently opened up our first US office, and we expect there will be further US offices over the next 2 to 3 years. We expect to open in Singapore at the start of next year. We're growing here in London, and we have our eyes set on Latin America through a joint venture with a Brazilian funder. So we're always in the market for good litigators, and perhaps more importantly, good deal makers, good originators. Our ideal employee, whether they're on the litigation side or on the origination side or even on the finance or other elements of our business, they need to understand litigation. They need to understand the dynamics of the claimants and the defendants in the matter. They need to understand how law firms work and the economics of the business of law and the economics of litigation. They've got to be curious and want to be able to have the diversity and flexibility of portfolio that we have, where one day we might be looking at a high-value divorce and the next day we're looking at an environmental mass tort. Curiosity is required for that. And ultimately this is an entrepreneurial business in an entrepreneurial, fast-moving industry, so we want good business people. Check out the website, woodsfordlitigationfunding.com.